Good evening, Commissioners. Thank you for the audience, and congratulations, Commissioner Taylor, on being seated. Will this new government that is being formed be required to comply with Public Records Law of Florida? And will those meetings have to comply with government and sunshine standards? This bill seeks a pledge from the legislature not to interfere with the bondholders' interests. This inherently places limits on the ability of the legislature to act or provide relief to citizens if and when they decide there is a need. Is this constitutional? And has this provision been reviewed by the governor, and has he agreed to sign it if it lands on his desk? This bill restricts the ability of the legislature to act in making changes to the charter in paragraph F, unless it complies with sections 189.031, paragraph 2, subsection E4. This is unconstitutional and encroaches upon the sovereign powers of the state legislature. So again, would the governor agree to sign this provision if it were delivered to his desk? Have you or anyone associated with this bill sought from the Department of Environmental Protection their analysis of the bill to determine what fiscal impact the bill would have on the state agency, or any opinion they may have on the proposed legislation? And who determines what are wetland areas? And who creates a plan for mitigation? On page 67 of the proposed local bill, there is paragraph E, a provision that grants powers to create rules under the Administrative Procedures Act. This grant of rulemaking powers is broad and sweeping and could have unanticipated impact, particularly when you consider Administrative Procedure Act has force and effect of law. I am perplexed why we would give such broad powers to a private company, and that could be used in a wide-ranging manner in ways that are at this time not even considered. Why are these powers needed? Since the transfer of power will not happen until this town hits a population of 47,000 people, this seems to me to be premature. Perhaps we should withhold this until a later date, until the people have control and the powers they need are truly identified. On page 68 of the proposed bill, under section K, it has a paragraph that allows the stewardship district the right and power to exercise eminent domain over any property within the state, except municipal, county, state, and federal property, for uses and purposes of the districts related to water, sewer, drainage, roads, including, without limitation, the power for taking easements for the drainage of the land of one person and through the land of another. This power is far-reaching as it includes any land in the state outside the exceptions noted. For a landowner that is next to the district, they could be impacted by this far-reaching power in this new government. There would be nothing the Board of County Commissioners could do in recourse about this matter. There is concern that this is an encroachment on sovereign powers of the BOCC itself. And could you explain to me why who would be providing fire services? Is there a plan for ambulatory service as well? In the bill, it is not clear if they function together as the county fire services do. Also, can you help me understand how the proposed security and guardhouses you plan are not an exclusive benefit to the district? Under the language of this legislative act, there is a public benefit as well. What sort of administrative rules under Chapter 120 of Florida statutes would you envision adopting related to guardhouses? For reference, this is on page 73 of the bill. Last but not least, one of the most important duties of the County Commission is to protect the health, safety, and welfare of the citizens. I do not see where or how this new government has been charged with the protection of the health of its citizens. There does not appear to be any duty or responsibility to offer health clinics, access to health care, services for those who cannot afford to pay for health care, no responsibility to contribute to the not-for-profit organizations that offer care to the poor and destitute in our community. I believe that with so much wealth that seems to be the focus of this project, it would stand to reason that somewhere in this legislation, which I have worked on previously as a legislative aide, that there would be some provision made for the poor, the needy, and the sick. I would urge you to require that they do their part and either provide a fee to the Board of County Commissioners or offer access to care for the low income that will reside in this district of 47,000 people. I brought many important questions to you tonight, but not all that need to be asked. If every board member can't answer these questions, I encourage you to please fully vet the potential impacts of this bill on your friends and neighbors prior to taking up a vote. Thank you.